Uh, Ma'am, this is Professor Bansode, and
Good
I
morning,
welcome you
Professor.
all. Yes, good morning, ma'am. Good morning. And I welcome you all the participants in this second session of startups and essentials of contract drafting. I thank to Radhika ma'am for giving insights on legal aspects of startup in last session. And I hope that this session also will be a great intellectual treat to learn the essentials of contract drafting. And so with this note, I request Radhika ma'am to start with this session. I request all participants to mute themselves. You can write your questions in the chat box. At the end of the session, we'll take up that particular questions. Thank you, ma'am. Radhika ma'am,
Yeah,
over to you,
yeah.
please.
Thank you so much. Good morning, everyone. I'm so happy and delighted to be here again and to share with you some of the insights that I've gathered over the years drafting contracts on different transactions. So we will begin now. One moment. One second. Yeah. So what we are going to do is that we are going to just look at the overview of what really goes into formulating and structuring a contract, and what are the kind of different elements of the contracts that we need to take care of while we are drafting them. So we'll begin with this. Just one moment. One moment. So to begin with, when we are looking at contracts, we need to first understand the essentials of a contract. So under the Contract Act, which was of 1872, for any understanding to be legally enforceable, it has certain essentials that we need to take care of. And these essentials are comprising of one, when there is a party A and a party B, let us say the party A wants to buy um, 5 loaves of bread from party B. Now, when the party A goes to party B and says that I would like to buy 5 loaves of bread, how much is it for? The party B says to party A that fair enough, I will sell you each loaf of bread for 10 rupees each. Now, in this simple conversation that they've had, they have just come to an understanding whereby one party has said that I will buy the loaves, the other party will said I'll supply you the loaves, and they agreed on a price and also the quantity in which it was to be supplied. This is a very basic and a rudimentary exchange that has happened within a contractual framework. Now, when we look at this from a legal standpoint, there are certain other essentials which are fundamental to contracts, and that those essentials are on the basis of one, the capacity of the parties entering into the contracts. For example, in this particular case, even a 10-year-old child can go to a shop and buy a loaf of bread. But when we are looking at legal contracts, it requires the contracting parties to one, be adults, two, to be to have the mental capacity to be able to enter the contract, third, to have the necessary power to enter into the contract. So for example, when you're contracting on behalf of the company, it is not enough for one to be either even a manager or an officer of the company to enter into the contract. The person has to be duly authorized to enter into the contract. And the due authorization for contracts happens by way of either a board resolution empowering a person to enter into certain kind of transactions, or in certain transactions where the contracts are very specific in nature, which are of higher value, which have higher obligations on the company, and are which essentially create a long-term relationship in ways of either a transaction or by way of a title, those contracts actually have to be tabled before the board, have to be reviewed by the board, and then ratified to say, yes, this contract can be executed, and we empower X, Y, and Z to enter into this contract. Hence, you can enter into a contract with a board resolution. The other way to enter into contracts is also through a power of attorney. Sometimes physically a person cannot be present to execute a document. So I can authorize a third party on my behalf to be able to execute this contract. Now, power of attorney, as the word suggests, is essentially a power given to an attorney, which means the third party, to enter into contracts or do something on my behalf. It could be anything. It could be a whole range of things that you could do. You could represent me before a regulator. You could go and buy a mobile property on my behalf. You could go and buy an immobile property on my behalf. So essentially, the importance of power of attorney is that it enables one person to act on behalf of the other. Now, power of attorneys are of specific kinds, and the reason why I'm sharing this with you right now, because as you interact with on businesses over a period of times, this will form a very important ingredient and an essential of your business practice, and you should understand some of the nuances of power of attorney. So first of all, power of attorney is governed by an act, and it's ideal that everybody is familiar with this act. Under power of attorneys, the essential two kind of power of attorneys are general power of attorney and a specific power of attorney. General power of attorney gives an just overarching general powers to act on behalf, to be able to do things on their behalf, and so on and so forth. In the earlier days, a lot could happen through a general power of attorney. But with complexities of law and businesses as they have come forth, including regulatory frameworks, for specific actions, you need to have a special power of attorney. For example, if I'm giving power to somebody to buy and sell shares on my behalf, or operate a bank account on my behalf, or to be able to do any other specific activity on my behalf, then you have to be able to have a special power of attorney, which specifically sets out what is it that we need to be able to do through this power of attorney, what is the power that I am giving to the person, as also what is the power that the person has, and also for safety reasons, what is the power the person doesn't have. For example, through a specific power of attorney, I can get a lot of people to negotiate on my behalf on the transaction. But execution of the document, I may not include in the power of attorney because I may want to myself execute it. So the power of attorney has to set out those details in detail. Secondly, you may have a power of attorney for an immobile transaction. And for an immobile transaction, a power of attorney always needs to be registered. We'll come to that in a minute. All transactions and dealings in regarding to an immobile property or rights in immobile property have to be covered by a power of attorney which is registered. Now, power of attorneys, if they are, which are where they transfer all the rights. For example, if I say, you can go ahead and execute a document on my behalf, whereby the money or the consideration comes to me, and the property also comes to vest in my name. For this, it is a limited power of attorney, which of course needs to be registered, but the stamp duty incident on a power of attorney, this kind of power of attorney, is a very minimal stamp duty incident. However, if I say I'm giving you an irrevocable power of attorney, which is irrevocable, which means I cannot revoke it, and the rights to do whatsoever with this document or the property comes to vest in you now, in which case this is going to be completely and fully stamped. We'll come to that aspect in a minute. And hence, when we are looking at contracts, what we understand capacity of a person, the person who's entering into the agreement has to have legal capacity, both from a standpoint of being an adult and to have the mental capacity, of a sound mind, but also to be able to have the right under law to act. So for example, if it's a minor child, right, if you're dealing with a right of a minor, if you're a parent, okay, you will have a right to deal with on behalf of the child. However, your right to deal on behalf of the child is in a fiduciary capacity, in the capacity that you are representing the interest of the child so long as the child becomes a major. Similarly, in cases where there are no parents, under the Guardianship Act, the courts appoint a guardian to act on behalf of a minor, right? So in terms of a contract, the essentials of a contract require a offerer, somebody who makes an offer, somebody who accepts the offer. There is a proposal, there is an acceptance, then there is consideration. It has to be for value. Now, sometimes consideration doesn't always have to be money. It has to be a valuable consideration. So it can also be mutual promise, whereby I say, I will do this for you, and you will say you will do something else in return for me. So as long as it's a mutual promise, it is fine. Any contract without consideration is unenforceable in law, right? So the other thing is consent. Consent in respect to the contracts also has to be given voluntarily. I cannot coerce you to sell your house to me. If through a coercion a house has been sold, then that contract is void ab initio, which means in certain cases where there is no consideration, or capacity of the parties is not there, or there is an unlawful object which is there, those contracts are void ab initio, which means it is as if the contracts did not happen at all. Whereas other contracts, where there is a misrepresentation, or there is improper information, or whereby I gave it to you under some understanding and you didn't have it at all. Those contracts whereby those can be remedied at the option of the party who was wronged or was under a wrong, who had the wrong impression when they entered into the contracts, are voidable contract. They can be remedied at the option of the party. So for example, there was a misrepresentation to me. And later on, when I got to know about it, I was still okay with the new facts, and I decided to still enter into the contract. In which case, at my behest, the contract is remediable. But there are certain contracts, like we talked about, without consideration in regard to capacities of party, like minors entering into the contracts, where there is an unlawful object. Those are absolutely void ab initio, right? So there are various kind of contracts. So the different kind of contracts that you will see always are of a wide range. And these contracts, depending on the nature of engagement we have, we will have to decide the nature of the contract that I need to enter into, as also what will go into the contract. So if you just take a look at the overview, one moment. If we look at the overview, so if you look at, I'm just going to go to the next slide. Yeah. So when we begin drafting a contract, there are a few things that we need to keep in mind. And this is just a broad outline of issues that are there. There could be many, many more things that you would consider. So the things that I need to keep in mind, first of all, is that what is this contract all about? Second, what is my bargaining position in the contract? So for example, if I have a particular property and I want to sell it, okay, and I want to sell it desperately. Now, when I'm entering into the contract, I already know that the need for me to sell the property, or the market is really down and I have found one buyer, then I know the bargaining position that I have today is a position which is a vulnerable position compared, it is a buyer's market, not a seller's market. And as a result of it, my own position for bargaining is difficult. However, if I know that although this is a property where I'm trying to sell in a market where there are no buyers. But to this buyer, this is an important property because it may be a corner property, it may be a property which is close to his other factory which may be there, or so on and so forth. I need to first understand when entering into the contract, what is my position vis-a-vis the other party uh, while entering into the contract. Second thing, before entering into a contract or even structuring the contract, I need to understand what is the regulatory framework that governs this particular contract. For example, if I'm entering into a contract connected with pharmaceuticals. Now, when I'm entering into a contract, let's say I was entering into a contract for contract manufacturing. When I'm entering into a contract for contract manufacturing, whereby I am giving a contract to a third party to manufacture products on my behalf using my technology and know-how, using the basic raw materials supplied by me. It is on a job work basis that I'm giving it to that person to supply. Now, when I'm doing this, I have to be very mindful of the fact of the licenses that, or and the regulatory framework that governs the product that is being manufactured. In this case, the pharmaceuticals, in which the Drugs and Cosmetics Acts comes into being. You will have the rules relating to packaging. You will have the rules relating to labeling, where you will have to set out very clearly who's the manufacturer, who's the person who's marketing, and so on and so forth. So whenever I'm looking at a contract, I need to look at the regulatory framework that governs a specific contract. The next is the commercial consideration. Sometimes what happens in contract, you don't do complete the entire um, uh, entire obligations at the effective date itself, on the date on which you have entered. In those contracts, the effective date becomes a date in future. For example, I have a plot of land in MIDC. Under MIDC, I have a long-term lease of, let's say, 100 years. Now I want to transfer this to you. In my original lease, there was a condition that before I transfer it to a third party, I need to take consent of MIDC. Why do I need to do that? One, because the land originally is owned by MIDC. MIDC will need to know what it is going to be for, what purpose it is, because certain times the industrial parks are for a specific purpose. Some of them will require an IT park, in which case you will need an ITES permission to do that. In some cases, they are of chemical manufacturing, and so on and so forth. The second part is, every time there is a change of hands, there is a premium that has to be paid to MIDC. So the proposed new lessee will need to make a payment to MIDC in order to come and take over the land. Similarly, in MIDC contracts, there is also another concept of change of control, whereby I may not be selling the land, but I may be selling my company, or I may be getting my stake in the company may be reducing below 50% or 51%, whatever is the threshold limit in the MIDC rules. Even there, I will need to tell the MIDC officials that there is a change of control happening, and thereby the person who is coming in will also need to make a payment, or rather the company itself will need to make a payment at that time to MIDC. So we have to be very careful and in understanding what the framework is. Similarly, when you're looking at commercial structure, what is the commercial structure? One, are there any condition precedents in the contract which need to be fulfilled in order for the contract itself to become effective? Okay. Typically speaking, you may need NOCs, you may need permissions. While I am taking over your property, I come to know there are 4 or 5 issues that need to be sorted out. For example, today the wall of the property is not in place. I need to have measurements of the property to be done. So for example, you tell me you're selling me 1,000 square feet of property. And today I want, or rather, let's say it was 1,000 acres of property. Now, 2,000 acres need to be, while you may have a document to it, I will also need to calculate the boundaries as well as the area, and to be sure that I'm actually paying you for the land that I'm receiving. What if there were encroachments? What if there were other issues, right? So you say that this is the price I fix up for this particular property. And the condition precedent will be, the measurements will be done by the party. Then depending on the measurements, with probably a margin of 1 or 2% that the parties can agree, anything above that or below that will be either paid to that extent proportionately more or proportionately less. In certain cases, there are regulatory permissions. For example, in civil aviation, I have an aircraft, okay? And now I want to sell that aircraft to you. The aircraft gets registered in the name of the person who was buying it, right? So these are long-term leases which are taken up by the company. So it's that lease model is held in the name of a particular company. So for example, Kingfisher had a particular aircraft. Now, when the Kingfisher aircraft needs to be transferred, let's say to Indigo, at that time, they will need to approach to the Ministry of Civil Aviation and say that this particular aircraft registered under so-and-so with this particular registration number is now being transferred to so-and-so. We need a permission to be able to do that. And then that post that permission, this will happen. So essentially, when you're looking at an effective commercial structure, you need to first of all understand what are the preconditions, one. Two, how they affect the commercials, the price, because when you enter into a contract, you're deciding a price as on that date. So sometimes it has happened that you have entered into a contract as on today, like, imagine some contracts were entered into just prior to COVID. And post-COVID, because of the situation, the entire business enterprise value got diminished considerably, at least for a certain period of time. Why? Because for the next few quarters, the numbers are going to be completely off. So let's say a private equity investor invested into the company pre-COVID with certain projections in mind. And since COVID, in the agreement entered into, the investment agreement entered into with the private equity player, if let's say pandemic or an epidemic was a part of a force majeure conditions, then this particular period cannot be considered for evaluating the performance of the company. In which case, there is a huge loss in terms of those PE players for a certain period of time, because their assumptions at which the prices were very high. In the reverse case, let's say during COVID, I strike a deal with somebody. I'm definitely going to get somewhat a better price than what I would get pre-COVID, for a simple reason: the market itself has changed today. So when I'm looking at a commercial structure, we need to keep in mind, we are not just looking at just now, but we need to take into account certain variables that may be there. So what happens is, sometimes we even peg prices. For example, when I'm looking at certain manufacturing of completed ready products, and if it is a price which is entirely fixed up and totally, I may need to say that I am fixing up the price, and let's say my key raw material was linked to crude oil prices. So I will then say that I am fixing you this price provided the oil prices are $dollars a barrel. If it fluctuates, say X% more or less, there will be a price revision. Okay, so you need to know your business really well. You need to know the transaction very well. You need to really know what are the risks that are pertaining to this particular transaction. You need to understand what is your own appetite for risk. Sometimes, you may get higher consideration, but the risks will be there. And we'll come to clauses later on. You will see, especially in clauses which are indemnity and other clauses, where they are open-ended liability clauses. While you're getting money, which may be really top money right now, your risks are not really contained by looking at risk mitigation measures in the contract, right? So for example, if people say that if there is a contract for a minimum guaranteed contract, whereby you say, I will make you a supply and I'll give you a supply at a fixed rate, provided you assure me for the next 5 years, you will take a minimum quantity of X ton of the raw materials year on year. So whether you take it or you don't take it, you have to make the payment for me in that regard, right? So there are certain contracts which are very strict contracts, and they are strict because either the raw material is in raw supply, or raw material or that service is in short supply and the demand is much more, or two, you're being able to negotiate a good price, and hence the seller needs to make sure that they will get a stream of income which will be uh, over a period of time, which will not change for any reason whatsoever. Such contracts also have very large and severe penalties for termination. We'll come to that in a minute. Next, very important point, direct and indirect tax considerations. How we structure the contract also has severe tax implications. And a lot of businesses are able to structure the contracts very well to be able to get maximum tax benefit. Now, you could get benefits by making sure that the governing law and the site of the contract, the place of the contract, essentially that you look at, the business of the contract you look at, can be a different country. For example, you may be operating in a different jurisdiction itself, and you may choose to be in that jurisdiction because it is tax effective. The tax authorities in India will also make sure to see that the place of control isn't India, because if all the decision making in respect to that contract is happening in India, then just by simply saying I have a company in Netherlands or a company in Mauritius is not enough, because they will say you're trying to just use that as a via media, when actually your entire business operation and the control and the decision making is happening in India. So you need to have really proper tax structuring to be done to make sure that it is efficient. There isn't too much loss on account of tax depletion, and hence that structuring becomes very important. And you need to have a very good direct and indirect tax consultants who will advise you in this matter. The next point is on forex issues. Forex issues become extremely important, especially when your payout is in forex. When I'm paying money in forex to receive my goods, it becomes extremely important to be understanding at what price am I paying these contracts. So if they are long-term contracts with commitment to purchase, I have to be very careful, because forex is always fluctuating. And you need to be then looking at forex covers if you require, because there are hedges, there are forex covers that you buy in order to be able to peg the price at certain levels. Now what happens is, when you're doing this, okay, if you just do it blindly, you're going to come into a lot of trouble, because companies, if you start tracking companies, you will see companies which do not have a natural hedge. What is the natural hedge? I buy a raw material, I import a raw material, and I export finished goods. Now, this acts as a natural hedge for me. Why? Because I am spending money to purchase, but I'm also receiving money for my products. In which case, I am a lot more insulated than a business which only is looking at buying buying material, or a business which is only looking at selling products. So we need to know that we need to understand the complexities of foreign exchange, the way they happen. We need to study that, and obviously have a very good person who specializes in this understanding and knowledge, who will advise. Because a lot of companies suffer serious losses on account of not having protected themselves on foreign exchange fluctuation issues. And it is they have they pay quite dearly for those fluctuations. The risk management is actually a sum total of evaluation of all kind of risks relating to the physical risk, my own facility, whether something happens there. In between, I mean, with pandemic and everything else, clauses relating to force majeure have been have been invoked, and there have been bitter battles which are being fought whether or not that force majeure is being covered under pandemic in the specific clause which was drafted. So that becomes an issue. We need to look at the risks relating to the raw materials, relating to the labor, relating to supply, even relating to delivery. Because when, if you are looking at contracts where delivery is going to happen, say through ships or through aircrafts or through, now imagine if there is a supply chain which was dependent on either ships or aircrafts, and the aircrafts itself have stopped functioning, suddenly you see that your business itself comes to a standstill, right? Unless you find alternate means or government opens up for emergency, or for certain businesses you're able to find alternates. So one has to be able to look at the entire risk that could go wrong in respect to anything, and then you have to provide for that flexibility in the contract. Now, when you're doing that, I mean, a successful contract is one which is a balanced contract from both sides. Because if it's an imbalanced contract, then the chances are it will never work, and it will always go into litigations, and um, uh, will have claims which are which make the entire situation a very unviable and a difficult situation to sustain. Hence, the maturity and experience with knowing how to be able to draft the contract is very important, because without it, you really never can come up with a contract which can be able to deal with the situations which are constantly dynamic. Another very important point is relating to governing law, jurisdiction, and one point which is not here but which will come ahead is dispute resolution. How, first, what is the law governing this contract, whether it's an Indian law, whether it is a law from somewhere else? How comfortable am I in understanding that particular law? Do I understand the legal framework on that, the costs which are included there for such litigations? Because they are extremely expensive and prohibiting, they are very prohibitive. So as a result, any dispute resolution issue is, generally speaking, best settled between the parties through mediation or through constructive discussions, rather than taking it to courts, because the time and effort taken for whether it's courts, and though arbitrations are much better now, but still they are lengthy and very expensive. So that is very important. As also jurisdiction, we need to also understand jurisdictional laws. For example, if your company is based in Middle East, where the laws are extremely stringent and strict, we need to understand that while you may get a certain tax benefit, the legal framework is an extremely stringent one. So one will then need to determine and decide what you need to do. And in some cases, you don't have a choice, because, for example, if it's a technology know-how sharing contract or a licensing contract, now the technology is coming from another place. We will need to enter into that contract because I need that technology, or your client needs that technology. So then you need to be able to see what is the best way you can enter into a contract to be able to protect the interests of your client. So the important thing here is, whether we are lawyers or non-lawyers, there is no substitute of understanding the basic framework that is required for putting together contracts. Okay. Second thing is that there is no substitute also for a logical, rational understanding of the entire transaction, also based on common sense. Because typically what happens is, lawyers or even young practitioners may say, I have the format or the template for the contract, right? I'll take it and I'll draft it. But what we need to understand, that the template is a skeleton overview of which gives you a basic understanding of what should go. Ultimately, the facts are the ones which will determine ones which are most important to be able to determine what is happening where, including in regard to employment contracts where people are going into employment. It's so important to read the contract to understand, at least as far as the risk is concerned, whether that has been mitigated, right? Because if you remain, or sometimes there are clauses which, although they are not enforceable under law, but there are clauses that you will not you will enter into a contract with me, let's say for service or for supply, and then while you're doing that, um, uh, you will not do a competing business after termination of this particular contract or expiry of this, um, or not interact with any other clients which are my competitors. Now these kind of things where we talk about in contracts, there are certain covenants which are positive, which means you have to do certain things, and there are certain covenants which are negative, you will not do certain things. So you need to be aware of both things, what you are going to do and what you are not going to do. Okay. So now we just come to one. I just thought as a property, we should just quickly glance through the contracts, because it's a very important and essential ingredient of any person's life cycle in a business. So when we are looking at property, obviously there are tangible property and intangible property. We'll do once a session on both tangible and intangible, but it's a whole universe unto itself. So when we are looking at tangible property, you have both a movable property and an immobile property. Tangible property essentially in India, the act which governs it primarily in terms of the principles is the Transfer of Property Act. And this is an act which gives you a basic overview of what are the kind of laws that apply and what are the kind of mechanics that apply in terms of a immobile property and a mobile property. So whenever we look at any bare act, okay, any law, the best way to start with a law is the bare act, and just making sure you go through it in detail. In fact, for all the young lawyers that I meet, I always encourage them in, at least having read some of the most essential laws that are there. And there are roughly 12 to 15 laws which are absolutely essential for any lawyer to read, and all of those laws have to be read by you through the bare act. Now you will ask me, how do I know which laws? Of course, that is something your teachers can guide. We can have a separate discussion on that, but you need to make a timetable whereby at least in half an hour, 45 minutes a day you dedicate to reading of law. Because if you can do that, can you imagine half an hour for not even 365 days? Let's say you do it for 250 days a year. It's very clearly 125 hours of reading. And when you read in a relaxed manner, not for exam, not for a purpose, you're going to absorb so much more, and it's going to be a lifelong knowledge for you and discipline for you going ahead. So anyway, tangible and intangible property. Tangible property governed by basically with Transfer of Property Act. In case of an immobile property, um, and we'll come to that, there is a whole system that governs it. Similarly, in case of intangible property, it's essentially, as we described the last time, property which is not material. When I say material, means you cannot touch and feel it. Byproduct of it is material, but the rights of it are held in basically either creative aspects of it or something which is unique and novel aspect of it. So if you look at generally as an overview, I'm just not going to go into too much detail right now, but just as an overview, when you're looking at mobile property, right, you will be entering into either sale of purchase agreements, whereby actually the right and title gets transferred from the seller to the buyer. In license agreements, where I can license you, I can get into short term or long term. I can license you, um, uh, lease you, sorry, my laptops. An organization needs 100 laptops. They don't need to buy it. They can do either in a hire purchase arrangement, they can do a long time lease arrangements, whereby the ownership remains with you, but you essentially give it to use to another, and you also then set out terms and conditions of how to do it and all of that. The other is also in terms of movable property, you also have the other is also assignment. So what happens is license and assignment also comes in where you're dealing with intangible property. So for example, software, Microsoft can license its software to millions and millions of users while still continuing to own the title ownership and the intellectual property rights in that particular software. As far as assignment is concerned, assignment as far as any intangible is concerned, there all the rights essentially gets transferred. But the beauty with intangibles is that you, as also with even tangibles, is you can even retain the rights. For example, if I had two plots of lands which were very next to each other, and plot A and plot B, and I decide to sell the plot B, but I want to use the same entrance that is there that I have been using forever, because the entrance is much broader from the side of the plot B. So when I'm selling the plot to you, I may say that, I will retain the easement right to use this particular the right to use this particular road, so that I can also have access to it. So contracts are, there's no hard and fast rule. You can essentially craft the contract to the need that we have. Now, in all contracts, stamp duty payment is essential, and stamp duty is governed by the Stamp Duty Act. This is a state subject, and there are stamp duty implications in respect to each state. In Mumbai, we have the Bombay Stamp Act, and we need to look under the Bombay Stamp Act to look at what are the kind of stamp duty implications that are there under various things. So one has to be familiar with this concept, and there are various considerations that go in being able to compute the stamp duty. So there are certain things where you will just simply say, okay, power of attorney is X, affidavit is Y, and that is simple. But when you go to contracts, you will have to get into the details to look at whether it's connected with intellectual property, whether it's connected with services, whether it's a money contract. All of that nuances you need to know. So you need to understand how to look at the Stamp Act. Similarly, also when you are looking at essentially recording it. Now, if you have contracts which are connected and specifically in regarding to IPR rights, you may need to want to record. Like for example, if I'm a licensed user of an IP, I may actually want to essentially then register that particular contract with the trademark registry to be able to have that right and to be able to use licensed use, on the logo or the brand that I have. Next, when we come to immobile properties, um, uh, the first thing, just give me one moment, okay? One moment. I'm sorry, there was a disturbance outside the window. I thought better to shut it. So, as far as the immobile properties go, one of the things that we need to remember is one, of course, we will need to look at the fundamentals which are set out under the Transfer of Property Act. And they are essential ingredients that go in the drafting of the deeds in regarding to immobile property. So we have to be familiar with them, and they have to be very precise. Why? Because if they are not precise and comprehensive, you can well land up in courts for decades of litigation, because title in respect to property was not properly transferred, or rights were not properly transferred, or something got left out. We did not include easement rights, let's say, or we did not include the access, or many issues. Or you may have entered into with certain group of people, but you forgot to include 2 3 other, say for example, if it was a Hindu HUF property, or if it was a property where the father or a mother had recently died, and although I may have entered into an agreement with the family, I did not really find out who the actual heirs were, in the absence of a will. And we have to know one thing, that as far as wills are concerned, basically I can only will right vested in me. So subject matter which is self earned, I can do whatever I want to, but which I have inherited, okay, then only to the extent of my inheritance I can give it. So for in certain cases, for example, if a young person unfortunately passes away, and if you don't know that, and if his wife goes and sells the property, and if you don't know that the mother and the child or the children also have share in the property, you can land up in litigation for a very, very long time, right? Because now the consideration is already flown to one faction of the family, and everybody else is saying, what about me? So these are the nuances that you need to understand. So whenever you're looking at title, the capacity is very important. Who's entering into the contract? Whether the person entering into the contract has a right to enter into the contract, whether that right is comprehensive, or have I left out somebody, So that becomes a very, very important thing. Or when you're looking at property, you need to then see, for example, if it is a flat in a cooperative society, you need an NOC from the cooperative society is mandatory. If the officer of flat is on a land which is owned by a collector, then the collector permission is necessary. So there are many, 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 many nuances in respect to each aspect of a transaction that we need to be aware of. And as we all know, ignorance of law is not an excuse, and it leads to a lot of problems. Hence, it's very important to be able to deal or have an advisor or be an advisor to a person, and be very competent, because people depend on us, so it is very important that when we give advice, one, we have studied things well, we ourselves are competent in law in order to be able to give that advice, and you take the necessary precautions in making that advice, and also collect the necessary facts. So this is an important issue that we need to keep in mind. In cases of property documents, leases, where it's either a long-term duration, which is above 5 years mostly, leave-in licenses less than 5 years. This we are talking about under right now, keeping in mind we are in Mumbai, and on that basis, you have to look at the applicable law for a particular jurisdiction to be able to understand the nuances in that regard completely. And stamp duties, as I said, varies from state to state. All real estate documents have to be registered. So right from power of attorney to any of the contracts, whether it's a leave-in license, lease, sale documents, easement document, renunciation. If I want to even renounce my right in a property, even that will need to be registered. One second. Yeah. Um, so one second. We've done that. So in addition to that, when we are looking at contracts, the contracts come in various forms as well. So you may have various arrangements that you will enter into, right? Those are also contracts, because although they come under certain framework, but they are also contracts. Why are they contracts? Because you set together a legally enforceable arrangement between different kinds of people. So for example, when you have a scheme of merger to be filed, the scheme of merger has to be drafted keeping in mind, of course, the necessary requirements and tenets of the merger that is entailed in respect to both the companies. However, we will need to not only now keep into account the principles of contract, but we will also need to keep into account all the laws which are subject matter, which are dealt as a subject matter through the merger. For example, first and foremost, the Companies Act. right? So you have two companies which are merging. You will need to know the necessary provisions under the Companies Act under which the merger will happen. If it's a listed company, then you will need to know the listing agreement requirements as well as the SEBI requirements in terms of notifications that will need to be done in order for this to happen. Now, of course, these schemes are filed in the NCLT, so you need to be able to look at all of those provisions also, right? Then you're looking at what is it that post this merger, what is going to happen. So one, of course, immobile property. So you need to know what is the underlying um, property that is being, so it could be like, right, the property could be across India, because you may have many offices in India, you may have different lands, you may have factories, you may have many assets. What are the immobile properties which are being taken over? All of that needs to be looked at. So all the trademarks, service marks, logos, brands, designs, patents, geographical indicators, whatever it may be, each whatever is there, the entire basket is happening. Employees are being taken on, right? Plus also what is being taken off, all the contracts. So all the contracts will also now be moving to the merged entity or under the ownership of the merged entity. So all the novation agreements need to be executed in order for that title to move to the newly emerged company. So it essentially, there is a whole universe that is applicable in respect to any action to be done, and you have to be familiar with it. Next, scheme of arrangement for the family. So a lot of times what happens is there are lots of assets which are owned by families. Okay, so it could be an asset, and there could be lots of businesses also. So let's say there is a family which has a family owned business for over many decades. Now, when we are looking at this, what essentially happens is, I need to first of all look at the capacity of each person on this particular who's entering into this family arrangement, because as I've said, minors can't. So the minors' interest will have to be represented through somebody, and then we'll have to come up with norms in regarding to assets which are in the family. Why? Because it should not happen that somebody will have a unilateral right to be able to sell their share or percentage of share. So parties come together to sometimes say that, okay, if I hold 10% share in the property, I will first offer that share to my remaining siblings. If they don't want it, then I can sell it to a third party, that too by giving notice to them, right? And also what happens is, in case of one thing, I forgot to mention earlier, that whenever you're looking at larger transactions, especially with connected with immobile properties, you also give notice to world at large by publishing newspaper ads. I'm sorry, there is I think you'll need to keep your phones on mute.
Yes, all
Hello?
participants, please mute
Yeah,
yourself.
but you, as a coordinator, you can do it for them. Mute,
Yes,
acha,
ma'am.
but
Yes, ma'am. Yes,
except
ma'am.
for me. Yeah. So, so essentially, you can give a notice to the world at large, and whereby, uh, if, for example, if I'm buying a property, I will say that I hereby give notice in regarding to the interest to procure a land which has been set out in the schedule down below, and any person with any kind of right, interest, any claim in regard to this, please contact within 2 weeks, and if not, please note that you would have waived that right. Now, although I may say this, it's not as if that person's rights goes away, but at least I have done my duty of being able to saying buyer, telling the world at large that, hey, listen, I'm going to be buying this property. So if you have any claims, that please come up to it and talk about it right now. So similar in family arrangements also, you need to sometimes construct different mechanisms whereby people get appointed. For example, it's a family. Let's say there are 5 factions of family and multiple members in that family. So then you say that party X and Y will be having a right to negotiate on our behalf. Will be able to do everything. Of course, as I said, the selling part of it will happen. Either the members can come directly, or even a power of attorney can be done, but the power of attorney is a limited power of attorney only to be able to sign. The money has to come in my name. or not even to sign. I'll come and sign, but you can do everything that is required. Sometimes court orders are needed, to be present in the court. All that can be done. Then you have settlement arrangements. What happens is that parties have been having disputes for the longest time, okay? And parties, there are litigations, there are arbitrations, and year on year, this thing is just dragging on. Colossal waste of time, money, effort, everything has been made. Then suddenly parties say that, listen, we have spent so much of resources now. I think we need to look at another option of maybe conciliation, mediation, or through negotiations. And then the parties arrive at a solution. Now, when they come to solution and settlement, just by entering into an agreement, it's not going to go away, right? I need to make sure that tomorrow you will not say that I rescind back or I go back on my, one moment.
Ma'am, please unmute. Yes, Radhika ma'am, please unmute yourself.
Bansode, can you unmute her?
Yes, ma'am, I enable that option.
Okay.
Yeah, because I needed you to do that. I was trying it unless
Yes,
you
yes, yes. I done that,
unmute.
ma'am.
Yeah,
Yes.
thank you. So, in case of settlement arrangements, we have to make sure that, after the parties come to a settlement, it shouldn't happen that they go back on it, right? So the sanctity is to be maintained. So what we do is you enter into a settlement arrangement, which gives the broad outline, the terms and conditions, but you go back to the court where the litigation has been filed and say that now this settlement we'll be filing in the court by way of a consent arrangement, and the consent arrangement will be ratified by the court so that it will have the sanctity of law. And if I decide to sir, I'm just going to mute once again. I'm sorry, I have a tickle in my throat, so just please unmute me once later, okay?
Yes, yes, ma'am. Please.
Yeah, sorry. So it is very important to go back to the court. So what happens is when you enter into agreements, we have to be very careful that it shouldn't happen that parties enter into the agreement and file another case, right? So what we do is the settlement that happens becomes full and final. And you need to have very specific clauses under those documents to very clearly say that this is a full and final settlement, no claims are due, we will not file again any other claims or something on the same subject matter, so on and so forth. And then this gets filed in the court, and parties file a consent term, and the court then gives an order in this regard, thereby bringing the sanctity of this particular law. So you will also see recently a lot of times, because of the IBC insolvency that is that opportunity or other filing opportunities there to the lender, so many assets have been seized, the assets get sold off. In these cases, what happens is, what is very important is the purchase of those assets. Really, everybody's worried, what if something goes wrong? Then the law came up with a framework to say that whenever these are being sold off, and through the processes of through the process and through the court, it gains its sanctity, and then you will not have issues thereafter. For example, if I were to take on a business now, naturally that business is in under the IBC because of the fact that they have defaulted on their loans. So there'll be so many claimants, right? So there are secured, unsecured creditors. When I buy the business, I don't want to be saddled with all those problems. So I want a clean slate in respect to what has happened in the past to take this forward, because I am taking it over with the assets, with the employees, with as a running business. So these are nuances that we have to be very careful in understanding. And that's why you need to know the facts we need to know, so diligence, due diligence that gets done, the legal diligence that gets done is a very, very, very important aspect of any transaction. How well do I know the transaction? How well do I know the subject matter? How well do I know the people also? Because what happens in today's case, there are people who may be making a distress sale, and maybe that property may already be encumbered somewhere else. So I need to do due diligences, I need to do title searches to make sure that they are not encumbered and they're not registered in the sub-registrar's office. I need to make sure that there are no Ministry of Corporate Affairs filings where encumbrances have been created. I need to know that this is not a person who's already been designated as a defaulter under IBC, because then what happens is, if your property was by way of trying to make sure that the lenders or the people who take possession or custody of all the assets, mobile and immobile, of this particular person, the courts may intervene, or the resolution professional may intervene to even to basically reverse the transaction, or to be able to say this is an illegal sale. Now what happens is, it's not that eventually you may get that money if it is still there with that person. Okay, if the person has spent it, you're not even going to get it. But you will be again subject to courts, you'll be subject to so many problems. So you have to be very careful. Last point, and of course there are literally many kinds of arrangements. I've just put here some examples. For example, say a shareholders arrangement. Why shareholders arrangement? Because there may be different people with different interests. Some people may be investors, some people may be promoters, some people may be, if it's a listed company, it could be just public at large. Now, in cases where they are mainly people which have put in money, or are driving the business, or need to have control over the business, they enter into an agreement called a shareholders agreement. That shareholders agreement is only enforceable provided the company itself is a party to it, and this shareholders agreement also needs to get reflected in the articles of the company, because the charter of the company that governs the company is the articles of the company. And unless and until you put in, say for example, under the shareholders agreement, if you have a right that in respect to certain matters you need my affirmative vote, right? So they are restricted matters. For example, when you want to sell assets, give a guarantee, change the auditor, change the business of the company, any of these very critical issues, and the investor says I need to have a say in the matter. So, and that right of the investor to be able to veto a matter, in spite of the fact that they may be holding even 18% of the shares and the other person holds, let's say, 80% of the shares, still it will be enforceable as long as company itself is a party to it and it is also in the articles of the company. So there are various nuances, and then there are, under the shareholder arrangements, many rights which are there, which enable, right to first offer is there. There is a tag on right is there. Many different kinds of rights come in, tag along rights, whereby, especially in the recent times when investors are investing in money with huge valuations to take certain share in the company, they want to make sure that their share remains protected. Now, how do they protect the shares? They protect their own share or their investment by making sure, one, that the promoters or the company cannot do things which are against the interest or the business interest of the company, by putting certain checks and mechanisms. That's one. And two, if in case the returns are not possible, or for example, if it's a private company and a investor has come in and they were looking at an exit maybe in 5 to 6 years, and hence there were provisions in the agreement which said that either this particular company will get listed, whereby the shareholder, the investor shareholder, will get a natural exit for its investment, or where you're looking at a scenario a third party may buy their shares, or a promoter itself will buy their shares. So you prepare a framework in this particular arrangement whereby rights of parties are protected. Similarly, the promoters also may say that, listen, if you want to sell your shares, you first sell it to the promoters and not just to anybody. And hence that the arrangements get done. So essentially, different arrangements are entered into, keeping in mind different kind of complexities. These arrangements are not just, in terms of services or buying or selling. They may be equity infusion. They may be in respect to governing how certain rights between parties will govern in respect to either a common asset or a common business, or a common pool of assets, it could be, or also settling the disputes that may have been there for the longest time. One second. Then you have the commercial contracts. Commercial contracts can be a sale and purchase or a service related contract are there. All of these again have to set out very clearly who the parties are, what is their roles, what is the contract for, what are the obligations. We'll just come to that right now. So just to what I'm going to now do is just take you through, just give you a snapshot and overview of a term sheet and a contract. Okay, so right now it is around 11:13. I should in the next half an hour be able to cover these two things, and then we can look at question answers in case if you have any. So the first thing is in terms of the term sheets, right? So what is a term sheet? Term sheet is essentially a skeleton of the most important key terms which govern a proposed relationship, whereby it is a precursor to a definitive agreement that will get signed. So what will happen is, if there are certain agreements, okay, that will be signed subsequently, it could be a sale agreement, it could be a services contract, but parties want to today just get a broad outline set out. Earlier, this used to be also, term sheets were also called as memorandums of understanding. And it was just that, it was just a documentation of an understanding. So the term sheet needs to also very clearly set out, as also an MOU needs to set out whether it is binding or not, because otherwise it's only a broad understanding. So we have to be careful on that. And it just sets out the key terms in a very simplified fashion so that parties can do some groundwork in that regard. For example, if I need to take my board approval, right? But I have struck a nice deal with you. So I put together on a piece of paper a broad outline. And I then go back to the board and take the permission in regarding to the arrangement that we have arrived at. Based on that, then we can get into a definitive agreement, which will actually set out the entire detail in that regard. Now, so when we are looking at contract, okay, so this is basically the overview of a contract. I'm going to just run you quickly through what the essentials of a contract are when you are looking at entering into one. So one, the parties to the contract, right? So as I've said, certain important things that we have to keep in mind, all the essential people that are necessary for the contract, should be a party to the contract. For example, I may be having a patent. A company may be having a patent which they want to license, or they want to assign their rights, transfer the rights. Now, the patent has been filed in the name of a scientist who works for me. If I have an agreement whereby the scientist has, under the employment also say agreement, it clearly says to the under that all the rights that get created in course of employment will be owned by the company. But for some reason, the company, instead of just putting that the inventor was so and so, his name also continued to remain there for whatever reason. We need to then make sure that he is also a party to the contract. A lot of times, you may even make certain people parties to a contract just as a confirming party. Why? Because it may happen that I am the owner of technology. I'm giving you a certain technology on license. In your agreement, there is a clause which says you may appoint third parties to be able to do X, Y, and Z in respect to this license, but you will at all times remain to be responsible in that regard. Because it's such an important clause, right, whereby even let's say that agreement even have a right not only to appoint, say, I am party A, your party B. I am the original owner, your party B, whom I have given you this license to use the technology. And in your contract, I have even given you a right to assign this contract to somebody else, to party C. Now, because this right to assign is there, which means you can actually transfer your license to somebody else also. And that party C will step into your shoes. Party C says, okay, fine, I'll do the assignment agreement. You have the right, but this is too big a deal for me. And the payout is very large. It's a large amount of money I'm paying you. I want the other party to at least give me on a letter saying that I have an NOC, I have no objection, you doing it. Or better still, come in as a confirming party to this particular document so that there is no problem. So you may choose who the parties to the agreement will be. This is very important. Second thing is that, as I said, what is important is the place of the contract also, because in certain places, jurisdiction, when you come to the clause relating to law, jurisdiction, and dispute resolution, parties will say parties can move to the appropriate jurisdiction for filing. So where can the contract be filed, or which court has a jurisdiction, can be determined by parties having agreed it in the contract, or based on certain principles that are followed under the CPC that is there, and one has to decide accordingly, including one being place of execution of the contract, and also pace of performance of the contract. So it is extremely important where the contract actually got performed. Then the recitals. Recitals are essentially a precursor giving a background of what this contract is all about, who the parties really are, what is the intent and purpose of entering into the contract. Then you have the definitions and the interpretation. Definition clauses are in order to make it easy for everybody that a same terminology is used across the contract consistently and has the same meaning. Right at the upfront, we define certain provisions, and then we use those certain terminologies across the contract, and everybody can understand what it essentially means. It's also a very effective way because you don't have to say the same thing again and again and again. So otherwise, I'll be saying a product which is manufactured in, every time I use the word product, I'll have to say so-and-so product, which is of specifications X, and with this kind of chemical analysis. Instead of that, once if I define it, I don't need to repeat it again and again in the contract, right? So there are various definitions that get defined, and it's a very important thing. What happens is, especially when you use templates, you have to be very careful, because a definition of, for example, confidential information in one transaction may differ from a confidential information in another transaction. A definition of how intellectual property rights is defined in one transaction will differ from another, because you may choose to include certain things, you may choose to exclude certain things. All of those nuances will need to be tied in properly. Then you have interpretation clause, how the contract will be interpreted. So for example, if I'm referring to an act, I may say that even the further future enactments in that regard will also be captured. So it doesn't have to be only one particular act of arbitration and conciliation of 1996. It can be, it would necessarily mean, and all the amendments subsequently. When you are saying a contract, I would say that it includes the recitals, it includes the contract, and it includes the annexures and schedules. Because in certain cases, whether or not, we'll come to that, what are schedules and annexures, but whether or not they are part of the contract is essential. You may want to put an upfront there itself that all obligations are on this contract are on time bound manner, and time shall be the essence of the contract, which means if the contract is not performed on the time that I have specified it, that the purpose of it is itself is vitiated. Of course, in the provisions of the agreement also, we will bring it out in terms of importance, because if certain things are done beyond, like for example, I wanted something for a wedding, right? I wanted my invitation cards to come for a wedding, and if I've, let's say, paid ₹1,00,000 for it. Now, if you decide to deliver it to me after that and demand me the money, and when I have told you specifically via email I need it, let's say 1 month before the wedding, it's no point if it comes to me on that day of the wedding or after the wedding, right? So time is extremely is important to be able to be specified when the performance needs to be done, because sometimes it is the basis on which is essential to the performance itself of the contract. Then the scope of the transaction. What is the scope about? What is this transaction all about? It has to be tied in very tightly right up front so that we understand who the parties are, what their roles are, what it is for, when, in what manner it has to be performed, what is the consideration for it, what is the basis of it. All of this has to be put up right in the front, and then say it will be governed by the terms and conditions of this particular agreement. So basically, in a contract, we look at what is the purpose of the contract, what is the time for performance, key terms of the transaction, what is the consideration, and what is the payment terms. Of course, we also look at the roles of the parties, the nature and precise roles. And as you start practicing this, or as you start thinking about it, it's very important. So a lot of time what happens is, if you take a ready precedent, you'll get all of this as a broad outline. But you have to understand, in fact, good contracts are the ones which are extremely efficient, and they are extremely precise. They have to be precise. Even the flexibility that has been afforded in the contract has to be precise, so that it doesn't become a loosely worded contract where just about everything can be read into it. If, like for example, if I say all future rights in respect to something also will be included. Now, when I'm looking at that, I need to understand how I'm putting it. Like all of us know, today under the Copyright Act, with the amendment that came about, it is not okay to just say all future rights will be done. You have to precisely today state what is it that you're giving. And if there is anything in respect to future, you need to make provisions to be able to see how those will get included also, with some minor consideration payments. But all of these things have to be thought through in detailed and specifically, right? So then you're talking about roles, you're talking about obligations of the party also. Why is it important to understand the role? Because if I have taken you because you're an expert on something, or you have the capability of manufacturing something, I am paying you what I'm paying you because you have that capability. Now, if you don't have the capability, it is not something that I can just go somewhere else and get it done. This becomes very important when you want to have specific performance. So there is an act called specific performance, which is also an essential act for every law student to read, which essentially tells you what are the grounds on which specific performances are required. They're essentially required where the loss is so large, if it is not performed in the manner and by, let's say, even by the person that it is to be performed, and in that manner. Because otherwise, it's like this, okay? You're an architect or a designer, and you start building my building, or implementing a project. You decide to suddenly walk away from the land, walk away from the project. It is going to be very hard for me, because I have obligations in respect to completing the project. I have deployed you, so now you can't walk out from it. Or I'm a movie producer and you're an actor, and you decide to walk out of that project. I cannot do that, because my film is already been shot half. And unless, of course, unfortunately, like in the case of Fast and Furious, if there is a death of an actor, then of course you have to use the next closest solution, or to be able to use then special effects and recreate. But otherwise, you need to get the courts to direct the person, no, you have to fulfill the contract, because the nature of the contract itself demands that I have come to you because you are going to do it. You're not going to deploy X, Y, and Z to perform that particular contract, you know. So let's say a famous musician is coming to sing, and you can't deploy X, Y, and Z. People are going to come to listen to Rahat Fateh Ali Khan. So, of course, he's not. So if whether he's available or not, unless of course you have a force majeure condition, and you cannot do it because of death, incapacitation, or the flights itself are not running, or something of that sort. So you need to understand the responsibilities of the company. Responsibilities of the company become very important, because this is what goes to determine the breach of contract. If in case you want to have a remedy for breach, first responsibility has to be clear, and also you have to appraise the other person that if this is not done in this manner, there will be a huge loss. Hence we are this clause becomes a very important clause in order to be able to put it. Then you have the reps and warranties. Reps and warranties are a very important provision under the contracts, because you set out the basis of what is the representation on the basis of which this contract has been made. I have represented that I have the expertise. I'm also admitting the fact that technology is yours. Tomorrow I can't use your technology right now and tomorrow claim rights on those technologies. So I put in those protections that I need vis-a-vis contracts, where I am actually sharing sensitive information with you, confidential information with you, technology with you, which is only to be used for a specific purpose in regard to my contract. I don't want you to use it for X, Y, and Z, everybody's contract. So these clauses become extremely important. Of course, they are fortified further in the intellectual property rights clauses, but the understanding is extremely important. The other important part relating to the beauty of the representations and warranties clause is, if in case, if you do something which is either a willful default, or you do a default or a breach, or you do gross negligence which was not commensurate with the duty you had under the agreement, I will not only have a civil remedy against you under the contractual law and act, but I will have a criminal remedy against you. And this is where the greatest protection under the contracts come, because for criminal breach of trust, or when I'm looking at other provisions under law where you made false representations and you enticed me to enter into an agreement on behalf of your false promise, I can also I can also bring about cases for cheating against you, or fraud where there is an element of fraud. So, you know, as a lawyer, when you start understanding the nuances of not just how you craft a contract, but how do you enforce the contracts and the underlying details of it, you will see it is so important to have your basics and your fundamentals in place. Because unless and until I know, you know, say for example, law of contract, transfer of property right, basic law like limitation act, I may put in you know, clauses, but I need to know how long is my claim going to be valid and subsisting under the law of limitation, or what do I need to do to be able to keep it valid and subsisting. Let's say there is the Arbitration Act, in IPC, Easement Act, as I said, and of course all the intellectual property right related laws, specific relief law, all of these law, your Registration Act, stamp duty, all of this are essential laws which are within the capacity of any decent lawyer. And now when you take, or the Companies Act as well, now when you take this list of laws that I have just mentioned, and if you look at your course, you know, your first year law course, second year law course, third year law course, or in case of 5 years, the 5-year law courses, you will see your entire course study has been crafted around these. And of course the constitutional law. Now if we decide to make sure that we study, you know, from let's say 3 TPs just before the exam and take an exam, how good is going to be my understanding of law, you can imagine. And God forbid if with that understanding I advise somebody without, of course, I've known a lot of people who also studied 3TP and went on to be really great lawyers, because later on they took on the trouble of studying law themselves and became amazing lawyers. So I'm not here to preach you in terms of what should be done, but I'm sharing with you the necessity of necessity of putting the hard work of studying the law as it should be. Because whether as the users of where we use the law or are protected by the law, or we are advising on the law, there is really no substitution for knowing the law. So then you have clauses like the confidentiality clauses, where you tell the person, how to treat the information. First of all, what information is confidential? How do you hold that information? How do you hold it? Whether if it is on your servers, can unlimited copies be made out of it, or that needs to be destroyed after time? All those details. For this, you also need to understand, the privacy bill that is coming forth, or the data protection laws which are there today. um, uh, you need to understand which jurisdiction you're operating in there, how the data protection laws are operating in those jurisdictions. We need to understand certain factual details, like let's say in your case, every time a file gets saved, it gets saved somewhere else in a mirror server. Then you need to tell that, listen, this is the problem in my company, I can't help it, I can't erase it out of every single server, so I don't want to make a false statement in my contract, so this is my reality, so amend this clause only to that extent, for nothing else. Then we also need to say that, whoever you part the information with, which may be your lawyers, your advisors, your consultants, whoever it is, they also will have to be bound by the confidentiality obligation. So it's not as if that the company is only responsible. It's directors, it's employees, it's consultants, all of them are responsible as well. And we need to provide for them. You have the non-compete clause where, so with non-compete, we have to keep into mind two things. One, that you have to be familiar with the Competition Act, which will tell you restraint. So two things: restraint on trade under the Contract Act, and two, under the Competition Act, whereby if you do unfair practices, or you come up with conditions which essentially stamp out competition, those are not enforceable under law. However, having said that, when I'm disclosing something very confidential, sensitive, price sensitive to you, which will have a huge repercussion if it's shared with somebody else. For example, if it's a bottling agreement, okay, and they are bottling it for, say, Coca-Cola. Now, if the person says, you know what, there is a Competition Act, you cannot prevent me from doing it, I will go ahead and do the same thing. Instead of Coca-Cola, I'll call it something else. No, that will not be permissible. Why? Because I have told you that it will cause me an irreparable harm. This is my proprietary knowledge and understanding. You cannot do that. Now, there I will put in those things, because I'm disclosing to you something which is specifically owned by only me. So something that is owned by me, the beauty is, where patents are concerned, know-how is concerned, technology is concerned, which is owned by me, and I can prove that it is owned by me and created by me, and it's novel to my and novel and created by me. I can even stop or prevent other people from using it. So when we do non-compete clauses, first, it needs to be done within the framework of law. Second, it also has to be reasonable. So for example, I have an employee who's working on a project which is very, very sensitive. If I put a reasonable clause, for 6 months, you will not work with a competitor immediately. And certainly you will not be sharing any information which is connected with my business or my clients or my technology. That I can certainly put, because it's my information. Similarly, exclusivity, that when you're doing this work for me and the kind of business that I'm giving you, during this period of time, you will be working exclusively with me and not with somebody else. So then you have the obligations of party we spoke about. Breach of obligations, we'll talk about what will amount to breach. You know, in certain cases, you don't need this clause. Obligations of the party is more than enough. But in certain cases, you know, where there can be a gray area and you want to be able to specify what will amount to breach sometimes, you know, you will need to be very careful there, especially where there are a lot of third party intervention. So you will say that breach is not only where you are committing a breach, but it's somebody through you is also committing breach, in which case the responsibility at all given points will be joint and several, which means it will be of that person also, but it will be yours also. Then you have consequences of breach. Now, in consequences of breach, there are, you know, various provisions of law, and this is a whole study unto itself. But it's good. It's a good study, you know. So liquidated damages. These are the provisions that one should look at and read. You know, it's also specific relief act. Why is these important? Because there is a whole law governing it to say what is possible and what is not possible. So where you have liquidated damages, they are not penal in nature, and then you have to put in clauses there to show. So, you know, where sometimes people say you'll pay 50% interest if something happens like this. So there are laws which talk about what is a permissible limits, how do you quantify breach, how do you quantify the damages. There is a huge jurisprudence in terms of case law which is available and created, and that needs to be understood. Then you have insurances. This is a very important provision because sometimes, you know, your raw materials may be with somebody else. There may be a fire. If you're not covered, it will be a problem. Second thing is, where is the title of the property moving? For example, if it was factory, right? You have the contracts where, in regard to this, where is the delivery going to happen? Where is the title actually going to be transferred from one party to another? Certain contracts happen in the high sea. You know, where the contracts, the title is actually of the goods is being actually transferred. All of these nuances we need to understand, because till the time it is in whose custody and title it is, that is the person which is responsible for that particular good, as well as any loss at that time will be to that person's count. So it is very important to understand where does the title or the ownership rest, whether it is in your control, custody or not, whether your insurance cover covers those eventualities. So it's again a big area of practice is insurances, because you need to understand your insurance cover. What does it cover? So, you know, sometimes it is for physical property, it is for mobile and immobile, it's for life, it's for accidents, it is for business disruption, business continuity, key persons insurance when somebody very important to business dies. It could be director liability insurance, you know, many different litigation where you're getting claims. So different kind of insurances get crafted for different kind of risks, where you have taken on a project and, you know, it overruns time. So sometimes what happens, like for example, if you're looking at in Mumbai, you know, metro project, say it gets stalled. The minute it gets stalled, everything goes offline. Why? Because the cost of financing keeps on piling up, to the cost of raw material goes up. So the project cost itself gets escalated. So unless and until you have buffers and necessary insurances covering this escalation in cost and price, it is extremely hard. And projects and companies have undergone through severe losses. Of course, then you have performances, how it has to be performed, the manner of performances, quality checks. You know, where will be the quality check done? Will it be done at their premises, in your premises? A third party will come and check. Where there is quality, then you have returns also, you know, where you can return goods and you can take it back. So there are many things which are connected with every kind of performance that we will know. What if something happens, for example, there is a inspection happens, or there is a raid, because of which particular products get seized. and it may be not your fault, but it may be unconnected with you, but is happening in the same facility where it is being manufactured. So there are many situations that one needs to think it through. All this is thought through depending the nature of contract, the how much is the tenure, what is the the quantum of the value of the contract. Then you have execution or definitive agreements. Certain times there are certain agreements which emanate from another agreement. Like for example, you're entering into an arrangement with a company for a turnkey basis, where there is going to be manufacturing on one side, that is let's say contract manufacturing. There is going to be a separate technology license agreement which is going to happen. There is going to be some R&D documents that's going to happen. Or you have a project and you have an EPC contract, which is an engineering procurement contract. There is an O&M contract, which is an operation and maintenance contract. So there are various contracts sometimes that go in respect to nature of work, right? So when you're doing, say, infrastructure work, the sets of contracts which will come there will be very distinct and different from when you're looking at a pharmaceutical industry. When you're looking at telecom, those contracts will be very different. So you need to have knowledge not just of the contracts, not just of the laws, but also the industry knowledge. So when you're looking at a specific industry, do I know which ministries are connected with this industry? I need to know that. I need to know the latest policy that is governing this particular industry. I need to know not only in regard to the regulatory framework for this industry, but I may need to know also how RBI is connected, the customs laws that are connected. So the whole life cycle of a contract, you need to first map. That life cycle of a contract will then give you the insight of how we are going to come and determine this, right? So we then spoke about, of course, then there may be condition precedents. Certain things need to happen before certain things get implemented. Then you have the breach of contract. How is a breach done? What are the consequences of breach? We need to look at. And then, of course, very important, as we talked about, the governing law, the mechanics of it. Now, a governing law, dispute resolution clauses all depend on the power of negotiation in the contract. If it is, I am giving you information, I am supplying you the technology, then I would obviously determine what the law will be. At times, parties also prefer a neutral jurisdiction, in which case, if I may be from maybe from England and you may be from India, and we may both choose that we will go for the Singapore UNCITRAL rules, although the seat of arbitration can be in India, and it can be so when you're looking at contracts, what's interesting is you will have the law could be different, the law of the contract can be different, the rules which will govern the dispute will be different. So for example, I'm doing an arbitration under the UNCITRAL model, right? So if I look at that as a mechanics, and the site can be yet another place completely. So all of this, we need to know, understand the governing details and do it. Then, of course, execution. When you're executing the contract, you need to have proper board resolutions. You need to have proper authority to execute. They all need to be adults, all of sound body and mind. You also sound mind, body, of course, only to the extent that the signatures have to be correct. Then you have also, now there are of course a concept of a digital signature, which is also there, so which is fine. But there is also, then you have schedules and annexes. Schedules are parts of the agreement where you set out details. For example, I may have schedule A for the details of the services I want. I may have schedule A or for the specifics of the specification of the product. My schedule B may be my delivery schedule, when will you deliver it, or the quantity schedule. My schedule C will be pricing, on what basis am I determining pricing. So all those details, instead of putting it in the contract, I may put it in the schedule. Annexures are, the difference between schedules and annexures are, schedules are drafted, created and put in to the agreement there itself. Annexures are documents which are from outside which are put in here. For example, a license you want to annex. A copy of the license is made as an annexure A. You want to annex another agreement to this agreement. That becomes an annexure. Sometimes they are also called as exhibits. So exhibits and annexures work interchangeably. Then what we talked about, stamping and registration. Depending on the contract, you will either stamp the document or you will register the document. Of course, there are various practices, but right now I prefer to take on question answers if there are any in terms of the overview of the contract, because we have roughly less than 15 minutes right now. So if anyone has questions, I'd be happy to take them.
Yes, ma'am. There are three questions, ma'am.
Sure.
Shall I read it
one
or
minute.
you
Where
can?
did you find the questions? Because I
Ma'am,
can't
in
see.
that more, that icon more is there in that
Okay,
chat
first let
option
me,
chat.
okay. Let me stop share. So
Yes.
we'll all can see each other if we can see, that is. Okay, where is the more, 1 minute, huh? Let me check the,
Beside participants, you will have that more icon. Na? So you click on that.
1 second, just 1 second. I'm normally, chats, I got it. Sorry about that. Oh, okay, my name not good today, can, okay. Yeah, in case of any immobile property, whether it's a family arrangement in respect to a property, yes, it will have to be registered. And you have to be careful about the stamp duty implication. So what happens is, to be able to enforce it, okay, so for example, we agree shares between us. You get 20%, somebody gets 30%, I get some share. Because it is connected with the property and rights in respect to the property, I go ahead and register it. I'll need to register it because it is only then going to be enforceable against each other. So that's why it is important to register it. There is a stamp duty impact on it. So sometimes what happens is people don't register it, but then we have to understand enforceability of that is a difficulty, because then tomorrow, even if say a third party, okay, uh, is dealing with us, then if it is a registered document, when they do a search, at least they know that this family has a arrangement in place and the shares are in this manner. But tomorrow, for example, if you don't have it, then what happens? So family arrangements, it's ideal for it to be registered, because it should be, especially if your shares have to be enforced. But I have also known people sometimes where they draft it, they execute it with on a stamp paper, but not on the, it's not fully stamped, and in a sense they will do it for 500 rupees just so that they put a structure in place. But it could lead to litigations, that is for sure. Then yeah, so power of attorney, you're right. So the power of attorney, it all depends. Like if a father can give it to the son, daughter, because they can't travel with medical certificates. So fraudulent happens where they are not properly stamped. But if they are fully stamped, for example, I'm selling my land, and along with the land conveyance, I have a power of attorney, then that power of attorney acts as an intermediate instrument which enables me to be able to use the power of attorney till such time my name comes up on all the government registrations and records. Then in terms of the books which are there, I mean, Tijoriwala and Divekar both are wonderful. I would, those are excellent. Then there are, Taxman publication has come up with many in terms of newer contracts, in terms of when you have collaboration and other agreements also. But by and large, I'll tell you, it's only through experience, once you start working, once you start learning, once you start experiencing. Plus, there are databases also which have various contracts. Uh, which make them available. You could take a look at that. How much does someone pay a lawyer to draft a contract? You could be, it's could be from 1 rupee to whatever the person can demand. It's actually it all depends on the complexity of contracts, also on who you go to. So it varies actually from people to people.
Ma'am, there is one question. Can a party plead frustration on account of COVID even if the contract does not provide force majeure?
No, so first for frustration of contract, we have to understand it's section 56 of the Contract Act. It is only when it is impossible to perform, right? So impossible to perform happens if you fit in within that definition, then yes. If something gets destroyed completely, it was supposed to be there and it's now not there at all, if it got burnt off or something like that, then I can't, right? So there is then, but you and I can't decide it. The jurisdiction or the court or the forum to whom we have given the power to decide the dispute will have to decide it. So this is something that we'll need to understand, that if both parties can speak and decide nothing like it, then you're sorted out, then you don't need a third party. But where people cannot agree on something, then you will need to and have to necessarily go to a third party forum which has been agreed under the contract. But yes, if the subject matter itself is destroyed, because of which there is frustration of a contract, it can be a ground depending on the facts. Yes. Normally speaking, in force majeure clauses, I know you've said there is no force majeure clause. We actually put a clause which says that if it is a continuing force majeure for a certain period of time, you can actually terminate the agreement.
Yes.
Yeah.
Now, are there any arrangements to be followed by the parties signing the contract if there are more than one person?
I'm sorry.
Are there any arrangements to be followed by the parties signing
Yeah.
the contract if there are more than one person?
So see, even if you are, say, 20 parties to a contract, because sometimes there are, especially in real estate and other, or even complex transactions when they are happening. So what happens then is the same arrangements work for everybody. I'll give you an example. In cases of certain companies where you are transferring a business, the articles of the company or the article of the company may require the company seal to be put. Okay, so you need, whenever you're entering into a contract with a company, you need to be familiar with the subject matter and how it is dealt with under the articles. So then each person will need to have a capacity, which means they'll have a board resolution or a power of attorney to enter into the contract. They will need to have proper signatures. There'll have to be witnesses to the contract. Then you will need to make sure that every page of the contract is initialed properly for being able to have evidence that no pages were tampered and changed with. If there were any corrections in the contract, those will have to be initialed. So even if there's one person or 100 people, the same practice is followed vis-a-vis all the people. So all the steps will have to be followed vis-a-vis all of them.
Yes, ma'am. So another, ma'am, can the economic hurdle to perform a contract on account of rise in price of raw material due to COVID pandemic be under frustration of contract? Economic
See,
hurdle to perform a
I've
contract.
understood. I've understood your
Yes.
question. See, the thing is, in most cases, though contracts provide certain things, if the contracts have not been drafted properly and if they do not give you a flexibility of force majeure, then in that case, you can certainly make a case to say that there is an impossibility of performance of contract because it was agreed at X price. Today, but the difficulty is not all contracts. So they say, I'll sell you X number of X material at this price. But they don't say that I'll sell you X at this price, provided the cost of raw material is benchmarked at this. So that's where the problem is. So in these cases, what the best thing to do is for parties to sit together and have a conversation. And, if you practically have a conversation with people to say that this is impossible to do this, so maybe, the order can be reduced, the size of the order can be reduced at this price, and then some more order can be placed at a differential price. So parties will have to come to an understanding in this matter, in reality. So because force majeure will only give you breather in terms of suspension of obligations. It will not take away the obligation to perform after the force majeure condition has come to an end. So that's the problem.
Now, one last question is there, ma'am. If a person makes a will, which is challenged and during pendency in court, family arrangement is made, whether one has to go to court to enforce it?
See, family arrangement can be made, there's no problem. First thing is that whether all the heirs are party to it. And if it is challenged and it is still challenged and the matter is pending in the court, then yes, you will have to file it in the court by way of a consent term.
So far, all questions are over, ma'am.
Wonderful.
And one, I think, personal question to you, whether any opportunity is there for internship in your firm or anything like that.
Sure. So, till the time we start functioning, because we are all right now working from home, we are not yet in the office.
Yes, yes.
I will speak to Professor Nilima, and we'll certainly do a program where every year, so some students can be taken as interns. That's not a problem. I'll connect you all with our HR team, and we can look at it. There's no problem in that.
Thank you, ma'am. Thank
Yeah,
you.
but the only one thing I have, and I this is my request actually. You see, what happens is the colleges and the teachers, are, of course, it's very important and pertinent which college I come from and which teachers teach me. But there is no substitute for self effort. I mean, this is something that we need to understand. We can't say that if we are genuinely interested in something, then we'll find a way to learn, so I think if you're interested, and I think all of you are bright students, I think all you have to do is want it bad, so if you want something bad, then you'll be the best at it, whether it's your education, whether it's your dancing, singing, cooking, whatever you want to do. So I'm just saying, first follow something you're passionate about. If you're passionate, you're going to study hard, you're going to work hard, you're going to you do it, then it won't bother you, you'll spend that time in library. And in any case, what is the point of doing anything if you're not going to do it well? So don't do it just as a degree, but do it because it means something to you. Then you'll automatically be very good at what you do. That is for sure. So thank you
Yes,
so
ma'am.
much. Thank you for this opportunity, and wish you all the very best. Thank you.
Yes, ma'am. Ek minute, ma'am.
Sure.
Ma'am, you structure the topic so well, and basically you cover the practical aspect of drafting of contract. The terms like regulatory framework, liability clause, term sheets, warranty clause, non-compete clause. These are the terms which are very new to all the students. And so I think this is something out of the box from the stereotype notion of learning the contract, basically. So thank you very much, ma'am. I would like to call upon principal, ma'am, to give some opinion or comments on this session, please.
Thank you, Bansode.
Yes, ma'am.
I'm really at a loss for words to thank Ms. Radhika Pereira. Today I'm understanding how difficult it must have been for her to squeeze out this time to be with us for these two sessions. It means a lot to us. And even especially that lovely PowerPoint that you have prepared, I would request you to share it with us.
Sure.
Radhika, your knowledge, your expertise, and your experience was so clearly reflected in the lucid exposition of the subject. I have been teaching contract law for decades, but today I realized how little even I know. The way you went on to give the key points of structuring of a contract, the property law, the arrangement schemes, the term sheets, overview of contract was simply amazing, And I agree with Professor Bansode when he said you gave them the practical knowledge, whereas we have been giving the theoretical. So I was thinking how we go about changing, the way of teaching. Like we may give the theoretical aspect, but everything is sterile and incomplete till you don't come in and give this sort of information in this interesting manner to them. So
Yeah.
a huge thank you for that. The second thing I want to thank you is, you were never preaching. What you said, these are pearls of wisdom for our students that do something out of passion. And despite the fact that teachers, colleges are there, they must read half an hour every day, the law. And imagine in a year how much more they can read, especially certain basic laws. And lastly,
True.
I thank you for even considering that we could have some internship programs with you. Radhika, with folded hands, I thank you. Thank you from the bottom of my heart on behalf of Nari
Thank
Gursahani.
you.
It has been wonderful. For years I have been waiting for this.
No,
Finally,
I am. So I'd like to just say one thing before I leave. See, um, Professor Nilima, I would never say that the teachings given by teachers are sterile. You see, what happens is there is a very big difference in law as it is, like the way we read it in books and the practical aspects of it. So that is applicable to everywhere. If somebody studies medicine and you go to a doctor and the person gives you an advice, that is coming from experience. So please, my request and prayer to all of you is understand one thing, that people have given 10, 20, 30 years, 40 years. Teachers have spent a lot of time studying and teaching. And you can never really say that this teacher is a good teacher or bad teacher. I don't agree with that at all, because everyone is teaching from their experience, their understanding, and their own exposure. So it is all good. The point is what we make of it after we get it. So the main thing is this, that if you were to stand in front of a class and take a class for an hour, you see the amount of preparation you will have to do that 1 hour class. So your teachers are doing that day in and day out, and there is a lot of study and preparation and knowledge that goes behind it to take that 1 hour of class. So one is understand that and respect it. And of course, the other good thing I would suggest, Professor Nalima, is within your teams itself, you all can make smaller groups, and I'll talk to you separately about it. In a month, you should cover one topic which a group of students will research, do, and present. By this, what happens is, even in 8, 9 months, you complete 9 topics which will get done. And if you do it across your students, you'll be surprised. In a month, you can do it twice. You will have 20 topics covered in a month, and you can do it in a hall, where larger number of groups of students attend. And it would be wonderful. You all can look at case laws, you all can look at this, and you can relate it to things that are happening in the world. Always take something and relate it to life, because the minute you connect it with life, it will always be more interesting. You'll say, oh, my uncle went through this thing, my aunt went through this, my friend's father did this. You'll see those examples are there with everybody in life. So law is not devoid of life. It's just to bring order to life. So once you understand that, I think we're all fine. But wish you the very best. It's been a pleasure, and all the best to you all.
Yes,
thank you.
thank you,
Thank
ma'am.
you.
Thank you
Thank you
very
so
much.
much. Such a
Ma'am,
pleasure. Yes.
officially, I would like to ask Heta to propose the vote of thanks. So please wait for 1 minute. Yes.
Good afternoon, all. It's my privilege to have been asked to propose a vote of thanks today. I, on behalf of Nari Gursahani Law College and Dr. L. H. Hiranandani College of Pharmacy and the entire supporting and organizing team here together, extend a very hearty vote of thanks to our speaker, Mrs. Radhika Dudhat Pereira, ma'am, for gracing your important work and sharing with us your findings and opinions today. I particularly liked Ms. Radhika ma'am's talk, where I learned many new things and various aspects that has to be overviewed for startups and for drafting contracts, as she mentioned in this webinar. The way she explained this subject was extraordinary. It It was a great pleasure and honor having you deliver this talk to us. Thank you, Radhika ma'am. We are really enlightened with your knowledge and presence. I would
Thank
like
you
to
so much.
acknowledge I would like to acknowledge the precious HSNC board for its constant encouragement for all our endeavors. We are thankful to our honorable principals, Dr. Nilima Chandiramani ma'am from Nari Gursahani Law College and Dr. Parag Gide sir from Dr. L.H. Hiranandani College of Pharmacy for their motivation and enthusiastic support. I must not forget to thank the organizing crew who are directly or indirectly have contributed to organizing this conference until the last days of the week. Our heartfelt thanks to our lovely participants for their active participation and coordination. With this warm words and a kind message, we would move to the end of today's webinar. I would like to thank again for making this event a success. Thank you, everyone.
Thank you very much. That's been such a
Thank you. Thank
pleasure.
you.
Thank you so
Thank
much.
you, ma'am.
Thank you for the opportunity.
Thank you,
Thanks.
ma'am.
Thank you,
Bye.
ma'am.
Thank you.
Bye bye.
Thank
Bye-bye.
you.
Thank you.
Bye.
Thank you. Thank you, Bansode.
I
Thank
would
you,
like
ma'am.
to
Thank you.
request
Thank
the participants to please fill the feedback form correctly with your correct details as it is automated. So any mistakes will not let you get the certificates. I have
yes.
posted the link on the chat box.
So link
Heta?
is posted. Yes.
Yeah.
Yeah, complete.
Link is posted for the filling of that feedback form. Please participants fill the feedback form so that you can get the certificates for that. Yes.
Yes, ma'am.
Heta, thank you very much. Are you there, Heta?
Yes, ma'am. Yes, ma'am. I can hear you.
Thank you very much. You have been with us for both the days, and I thank Principal Gide. Please convey my thanks to him.
Sure, ma'am. Sure, ma'am. I'll convey.
Thank you, Beta. And